sentenced to death. These few words have a chilling effect on anyone, including a hardened criminal. Dear viewers, I am Professor Sharanjeet, teaching at the Rajiv Gandhi National University of Law, and today we shall be talking about a very sensitive topic, that is the 21st century approach to capital punishment. We are very well aware of the fact that a large number of countries across the world have done away with capital punishment, and the rationale behind the same is that once a person is executed, the possibility of reformation is extinguished forever. Thus, in the light of the modern global human rights trends, capital punishment as a mode of sentencing has been abolished in many countries around the world. Restorative justice. While looking at the 21st century approach to capital punishment, one area of importance is the increasing trend towards restorative justice. Nowadays, the concept of restorative justice is gaining momentum. Retributive justice, which can be seen in the concept of a death sentence, looks at punishment in proportion to the seriousness of the crime and is based on the law of retaliation. Whereas restorative justice, as the name suggests, tries to restore the victim to the original position as far as possible. It looks towards improving the situation of the victim of the crime. Listeners, it is important to note that restorative justice works on four tenets. They are inclusion. Through inclusion, we mean that there is the participation of the offender and all involved in the crime, including the victim, family of the victim, police, lawyers, persons involved in correctional administration, and the community at large. The second tenet is encounter, in which the offender meets those who are willing to participate. The third is amends. Through this tenet, the offender seeks forgiveness for his wrongful conduct or criminal behavior and agrees to pay for damages or compensation, or works to restore the victim to the previous position as far as possible. And lastly, we have reintegration, in which the entire process, as discussed above, allows the victim to return to the pre-crime position with the support of all. Here it is important to refer to the findings given by eminent Professor Andrew Ashworth, who has done significant work in the field of restorative justice. According to him, the fundamental proposition is that justice for victims becomes a central goal of the criminal justice system and of sentencing procedures. He further said that restorative justice has considerable appeal as a constructive and socially inclusive way of responding to criminal behavior. However, the important question is whether restorative justice is appropriate with regards to those offences where capital punishment can be awarded on conviction. At the international level, the United Nations General Assembly resolution dated December 18, 2007 adopted a moratorium on death penalty worldwide. It is important to note that India voted against this United Nations General Assembly resolution. This moratorium was passed by a vote of 104 in favour, with 54 against and 29 abstentions. This resolution called on all states that still allowed capital punishment to progressively restrict the use of death penalty and reduce the number of offences for which it may be imposed. Dear viewers, on 15th December 2022, the United Nations General Assembly adopted its 9th resolution for a moratorium on the use of the death penalty. 125 votes were in favor of abolishing the death sentence, 37 votes against it, 22 abstentions, and 9 absences with regards to the abolition of the death sentence. Similarly, 29 countries in Africa voted in favor of the resolution compared to 17 in 2007. It is noteworthy that the United States voted no, placing it in the company of Iran, Saudi Arabia, China, North Korea, and Vietnam. It is interesting to note that every year, 10th October is observed as World Day Against the Death Penalty. As per the latest information pertaining to 2022 by the Amnesty International, 112 countries had abolished the death penalty in law by the end of 2022. A total of 883 executions were recorded in 2022, and China remained the world's leading executioner. It is important to note that excluding China, 90% of all the reported executions worldwide took place only in 3 countries, namely Iran, Saudi Arabia, and Egypt. Another controversial aspect in this regard is the execution of juveniles. As we all know, juveniles are dealt with by special legislations throughout the world, but the age of juvenility can be different in different countries. In the Indian context, going by the most recent changes brought by the criminal laws, the death penalty is retained as a form of punishment for serious crimes. Justification for the retention of capital punishment is primarily for the reason that in India, crime against women, particularly sexual violence, is not abating. A gruesome case that came in the limelight was the brutal murder of a girl named Shraddha by her own live-in partner in Mumbai, Maharashtra in May 2022. The accused had brutally killed the woman, chopped her body parts, and stored the same in the fridge. He would dispose of one body part every now and then, but was eventually caught by the police. So the very question in such cases is whether such cold-blooded acts deserve any leniency. Furthermore, terrorism also poses a serious threat to the security and integrity of the country. In the recent past, India was in the grip of urban terrorism and witnessed serious terror strikes in almost all the major cities of the country, and India was considered as a soft state in the face of terrorism. Hence, the lawmakers are of the view that it is not the right time to abolish the capital sentence completely. Surprisingly, capital punishment has not only been retained in the criminal laws prevailing in our country, but the amendments that took place to the criminal substantive law in 2013 and 2018 increased the number of offences where capital punishment could be awarded on conviction. For heinous crimes, particularly sexual crimes against women and children, capital punishment has been retained. In December 2012, a young physiotherapy student was gang raped in a moving bus in New Delhi. In 2018, a minor female child was gang raped in Kathua, Jammu and Kashmir, and eventually she was brutally murdered by her rapists. Even though there have been numerous such cases, these 2 cases were the tip of the iceberg and led to significant amendments in the criminal laws and the inclusion of death sentence for the rape of young girls. As per the National Crime Records Bureau report for 2022, crime against women rose by 4% in 2022 as compared to 2021, and a total of 31,500 516 rape cases were recorded in 2022 in India. Under the category of murder with rape or gang rape, the state of Uttar Pradesh topped the list again with 62 such cases registered, followed by Madhya Pradesh at 41. Dear listeners, the new substantive criminal law, that is the Bharatiya Nyaya Sanhita 2023, got presidential assent in December 2023 and shall determine the criminal liability for various acts and illegal omissions in the country. If we look at the approach adopted by this new law with regards to capital punishment, we will find that capital punishment has not only been retained in the new law, but new offences have also been created where death sentence can be imposed on the convict prisoner. Now we shall discuss the provisions for capital punishment under the Bharatiya Nyaya Sanhita of 2023. Under this new law, capital punishment has been provided for the following offences. Keeping in mind the high incidence of sexual violence against women and girls, this legislation provides a new chapter 5 that exclusively deals with sexual crime against women and children. The new law under section 70 subsection 2 states that where a woman under 18 years of age is raped by one or more persons constituting a group or acting in furtherance of common intention, each of those persons shall be deemed to have committed the offence of rape and shall be punished with imprisonment for life, which shall mean imprisonment for the remainder of that person's natural life and with a fine or with death. The objective is to increase the deterrence of the law with regards to rape of minor vulnerable girls in the country. Furthermore, section 103 subsection 2 of the Bharatiya Nyaya Sanhita 2023 has also introduced the offence of mob lynching. It has been provided that when a group of 5 or more persons acting in concert commits murder on the grounds of race, caste, community, sex, place of birth, language, personal belief, or any other similar ground, each member of such group shall be punished with death or with imprisonment for life and shall also be liable to fine. The next offence attracting capital punishment under this new law is the offence of organized crime. Organized crime has been introduced in the penal law under section 111. Organized crime has been defined in great detail and punishment for the same has also been provided. Under section 111, organized crime refers to any continuing unlawful activity including kidnapping, robbery, vehicle theft, extortion, land grabbing, contract killing, economic offences, cyber crimes, trafficking of persons, drugs, weapons or illicit goods or services, human trafficking for prostitution or ransom by any person or a group of persons acting in concert, singly or jointly, either as a member of an organized crime syndicate or on behalf of such syndicate by use of violence, threat of violence, intimidation, coercion, or by any other unlawful means for direct or indirect material benefits, including a financial benefit, shall constitute organized crime. Further, under section 111 subsection 2, punishment for organized crime has been provided, which states that whoever commits organized crime shall, if such offence has resulted in the death of any person, be punished with death or imprisonment for life and shall also be liable to a fine which shall not be less than 10 lakh rupees. Furthermore, in other cases the punishment shall be imprisonment for a term which shall not be less than 5 years, but which may extend to imprisonment for life, and shall also be liable to a fine which shall not be less than 5 lakh rupees. In the context of organized crime, it has been seen that it originated in Maharashtra in the form of underworld and mafia gangs which used violence, coercion, threats of violence, and intimidation to obtain an economic benefit. Gradually, it was seen that organized criminals like Dawood Ibrahim started funding terror operations in the country, which led to the emergence of urban terrorism. In the recent past, major cities of the country were targeted by the terrorists who received funding from the organized criminals, which led to loss of life and property and directly attacked the sovereignty and integrity of our country. In the new criminal law, organized crime attracts punishment even to the extent of a death sentence. It is felt that, keeping in mind the fact that organized crime and terrorism work in concert, organized crime should be dealt with sternly, and the death penalty is an appropriate punishment. Dear listeners, death sentence is also considered necessary for organized criminals because nowadays they indulge in a large globalized scale of human trafficking, drug peddling, and arms smuggling, which not only leads to serious human rights violations of the victim of the above mentioned crimes, but also casts an eclipse on the economy of the country. Another important aspect is the inclusion of the definition of a terrorist act in the new law. A terror accused on conviction can be given the sentence of death by the court under this new legislation. In the previous law, which is the Indian Penal Code 1860, a terrorist act was not defined, but such acts were included as offences in the chapter Offence of Waging War Against the State. Under the newly introduced substantive criminal law, Section 113 deals with a terrorist act. The expression terrorist act has been defined broadly, keeping in mind the threat posed by terrorism to the unity, integrity, sovereignty, security, and economic stability of our country. This section provides that whoever commits a terrorist act shall, if such offence has resulted in the death of any person, be punished with death or imprisonment for life, and shall also be liable to a fine, and in any other case be punished with imprisonment for a term which shall not be less than 5 years, but which may extend to imprisonment for life, and shall also be liable to a fine. In the Bharatiya Nyaya Sanhita 2023, the offence of mob lynching has been provided, and people indulging in this form of criminality can also face execution on their conviction. In a secular state like India, where the constitution makers envisaged that people belonging to different religious groups should live in harmony, brotherhood, and a feeling of unity in diversity, sometimes due to vested interests, certain people may indulge in communal violence, which many times has also escalated to mob lynching. The offence of mob lynching creates a fear psychosis and is detrimental to the secularism and unity of our country. Mob lynching promotes the idea of Gunda Raj, and thus this new inclusion in the criminal law of 2023 would definitely serve as a deterrent. Dear listeners, if we go by the present statistics of India for 2022, published by the National Crime Records Bureau, Ministry of Home Affairs, New Delhi, a total of 190 people were awarded the death sentence during 2022 in India. Here it is important to note that out of 190 persons who were given capital punishment, Gujarat reported 41 persons, and it was followed by Uttar Pradesh, where 30 were given death sentences, Jharkhand, where the number was 27, in Bihar it was 21, in Rajasthan it was 10, Madhya Pradesh 9, Karnataka 8, in Maharashtra and Tamil Nadu 6 people each, in Haryana 5 persons, in Tripura and Uttarakhand 4 persons each, in Assam, Chhattisgarh, Kerala and Telangana 3 persons each, in Andhra Pradesh, Odisha and West Bengal 2 persons each, and Himachal Pradesh 1 person. As per the latest information, the death sentences of around 51 convicts were commuted to life imprisonment. It is important to note that out of these 51 convicts whose death sentences were commuted, 23.5% reported from Bihar, followed by West Bengal 17.6% and Madhya Pradesh 13.7%. Dear listeners, another important aspect with regards to death sentence already discussed in the previous lectures is the death row phenomena. The National Law University of Delhi conducted a very significant study on the above phenomena. As per this study, which is the Annual Statistics Report 2022 published by Project 39A, until December 31, 2022, as many as 539 prisoners were on death row in India, the highest since 2016. Another aspect of the death sentence is the provision of commutation of the sentence to life imprisonment. Articles 72 and 161 of the Constitution gives power to the President of India and the Governor to grant pardons and to suspend, remit or commute sentences in certain cases. At times, it is felt that the commutation of a death sentence into life imprisonment is a balancing mechanism, as it does not take away the life of the wrongdoer, but he still has to suffer a lifelong incarceration. A case in this regard is Rajendra Prahlad Rao Vasnik versus State of Maharashtra 2018. In this case, the court commuted the death sentence of the convict guilty of rape and murder of a minor to life imprisonment without remission. The court observed that prior to the imposition of the death, the probability, not the possibility, that the convict could be rehabilitated and reformed in the society must be seriously considered. The court further held that the prosecution had to show the court that there is a zero possibility of reformation, and even in a case where social reintegration is impossible, longer imprisonment is still valid. Further, in the case of Jai Prakash versus State of Uttarakhand, the court stayed the death sentence awarded to the convict guilty of raping and murdering a minor, requiring a psychological examination to determine whether the death sentence is the only possible punishment. As the trend has shifted towards reformative justice, the same was also witnessed in the case of Mohammad Firoz versus the State of Madhya Pradesh, where the court commuted the death sentence on the grounds that a balance has to be drawn between retributive and restorative justice. In the end, I would like to say that the Indian Penal Code 1860 was framed by the British not only to maintain law and order in our country, but also to suppress the freedom struggle. The freedom fighters were executed to silence the freedom struggle. The death sentence as a mode of punishment was routinely used by the British to thwart the freedom struggle. After the independence of the country, the death sentence was retained. Many times it has been argued that the retention of a death sentence is violative of the international and national human rights framework. For instance, the Universal Declaration of Human Rights 1948, the International Covenant for Civil and Political Rights 1966 and the Convention Against Torture. But if we look at the other side of the coin, despite the fact that death sentences have been retained, in 2013 and 2018, the number of offences for which death sentence can be awarded has actually increased. If you look at the data provided by the National Crime Records Bureau, every year we will realize that the crime rate in India, particularly heinous crimes, has not declined. On the contrary, they are increasing with every passing year. Hence, it is felt that the retention of the death sentence is imperative, as it creates some kind of a fear in criminal-minded individuals. But as already settled by the Supreme Court of India, the death sentence can be used only in the rarest of rare cases. Nowadays, the global perspective is that a person who commits a heinous crime must be explored. It must also be determined whether it is possible to reform, rehabilitate and socially reintegrate the criminal or not. But the question still remains whether this approach coincides with the right of the victim to justice. With this, we come to an end of today's lecture. Thank you very much.